The silent witness. Why we muffle children in custody battles. One of the most deeply entrenched assumptions in family law is the idea that children should almost never testify in child custody disputes involving them. The rationale sounds compassionate on the surface. We do not want children placed in the middle of their parents' conflict or forced to choose sides. And in fairness, there is some legitimate concern there. Nobody wants to turn children into weapons in litigation. At least no decent person. But I think the modern family law system often takes this idea much too far, and we need to ask a harder question and a clearer question. Are we actually protecting children, or are we silencing some of the most important witnesses in the entire case? Because children are not just emotional participants in these disputes, they are often direct witnesses to the reality of their daily lives. They know who helps with homework. They know who actually shows up. They know what happens inside each parent's home. They know whether there is screaming, instability, neglect, affection, structure, substance abuse, or fear. Yet courts routinely place enormous weight on second-hand, unrecorded interpretations from custody evaluators, therapists, and guardians ad litem, while treating direct testimony from the child, reviewable testimony, as somehow uniquely dangerous to the child. And that distinction deserves more scrutiny than it usually gets. Part of the problem is that people imagine child testimony as some dramatic loyalty test where a child is asked, which parent do you love more? Or what do you want to do? Where do you want to live? But that is not the only thing that children can provide by way of information. There is a major difference between forcing a child to make a loyalty choice and allowing a child to answer factual questions about daily life. A child can testify about who attends school events, who helps with homework and how, whether arguments occur in the home, whether there is food in the refrigerator, whether one parent regularly disappears, drinks excessively, or frightens them. Those are factual observations. That is evidence. And frankly, in many cases, children have a clearer understanding of the family dynamic than the expensive professionals later brought in to interpret it. Which brings me to another uncomfortable reality. I do not think the biggest obstacle to hearing from children is always concern for the children themselves. A large part of the problem is institutional convenience. Proper in-camera interviews take time. Careful judicial fact-finding takes time. And family courts operate under crushing docket pressure. So instead, the system often outsources this process to the mental health and social work industry through custody evaluations and related professionals. Parents spend thousands, or sometimes tens of thousands of dollars for opinions that are frequently subjective, difficult to challenge, and sometimes dressed up with far more scientific certainty than they deserve. Mental health professionals are not magical human polygraphs. They can be manipulated, they can be fooled, and they can miss things. They can overvalue presentation and underweigh hard evidence. Judges and lawyers, for all their flaws, are at least trained in the mechanics and experienced in the mechanics of cross-examination, inconsistencies, and credibility analysis. Yet, ironically, we often trust evaluators speaking privately behind closed doors more than we trust carefully structured judicial interviews conducted on the record. And there is another reality here that people do not like discussing openly. The current system often rewards safe institutional bias. If a judge restricts a father's parent time based upon suspicion alone, the judge is often praised for erring on the side of caution and avoiding the risk. But if the judge grants substantial custody and something later goes wrong, the criticism can become severe. That incentive structure matters. In some situations, prejudice against fathers gets reframed as caution or child protection. And when courts refuse to hear directly from children who might contradict prevailing narratives, or maybe good-sounding narratives, those narratives harden into assumed truth. To be clear, I'm not arguing that every child should routinely testify in open court. That would create its own problems. But I do think the system has overcorrected to the point where children's voices are often filtered entirely through expensive intermediaries instead of being treated as direct evidence worthy of careful consideration. If a child is old enough to experience the impact of a custody schedule, that child is often old enough to provide meaningful, factual information about life inside the family. And maybe the real question we should ask is this: are we truly protecting children by silencing them, or are we protecting the comfort and efficiency of the adults running the system?